Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, folks, welcome to another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman. And this afternoon we have with us, I think you said you're in Maine, Sid Rao with the law firm Romano Law. Welcome to the show.
Yeah, thank you so much for having me, Jonathan.
Yeah.
I am in Maine for the holidays, but I am a New Yorker. Romano is actually New York City.
Yeah, I figured that. Where in Maine are you? Like in Portland or something?
In Rangeley, which is very close to the Canadian border. It's very remote. Western Maine. I think it probably took us about 8 hours to drive from Brooklyn to Rangeley.
Wow.
So it's great though. I mean, it's snowing out here. The Christmas tree is as tall as 2.5 people.
It must
It's a
be
whole different
gorgeous.
experience. So
Yeah, it must be
it's
beautiful.
really great. Yeah.
Yeah. I grew up in Boston. I've spent plenty of time in Maine. I've skied in Maine at Sunday River before. I don't know if you've skied there.
Yeah, I have not. I know that. So I know where I am. We're near a ski mountain. If it comes to me, I'll tell you. This is my fiance's family home, so
Got it.
I'm still
Oh,
getting
very nice. Yeah.
my main legs. Yeah, still navigating my way around.
Well, yeah. So, where'd you grow up?
I grew up in Texas, so there wasn't much skiing where I grew up. I skied a little. My mom was a doctor, and one of her patients had like a ski lodge, I think in Colorado, and so he was very gracious and let us use that one year, and so that was my first time skiing. I think I was 14 years old, if I'm remembering correctly. But then I went to college in Middlebury, where it seemed like everyone had been skiing since they were 3.
Right.
So it was a little bit different. And
Yeah.
yeah, it's a whole culture that in Texas, it's just for obvious reasons, not
Well, what
not a
city in Texas?
ski country. I grew up in Dallas, so
Oh,
the
okay.
big things in Dallas were, of course, football. I went to a very small high school, 80 people in our graduating class. I think 3 of them played Division One, and one had a brief pro career. So it was football was a big deal, but sports were always big. The Dallas Stars, they went to the Stanley Cup when I was in high school. That was huge because hockey had never really been a thing in Dallas, but it became a thing that year. So
Yeah.
but skiing and winter sports, tough in Dallas, Texas. Very
Got
hot,
it.
very
You're,
hot
you're,
place. So
you're in the
yeah,
wild now up there in Maine. It's a different kind of
yeah, very
wild.
different.
So
Yeah.
anyways, it's probably freezing up there. So, latte with a lawyer. What's your morning beverage of choice? What did you have this morning?
Yeah, so this is such a good question. I'll tell you what has been my beverage of choice until pretty recently. I have this little Bialetti mocha, which makes espresso, and so every morning it's like a stovetop espresso maker. I drink a coffee. It's very Indian style, actually. So I make the espresso, and then I heat up milk, and my fiance's converted me to oat milk. So I heat up oat milk, and then I mix the hot espresso with the oat milk, and it's kind of like a frothy, warm, rich coffee. That's how I like to start my day. But recently I've been trying to reduce the coffee, so I'm on ginger turmeric tea, which is a lot less interesting to
Ah,
say, but maybe good for a pause, a little break
all right,
from the
good.
caffeine. Yeah.
Yeah. Well, okay. So I talked to someone actually the other day was weaning themselves off of coffee. Why? You don't think it's healthy?
No, I just think it's good to take a break from things every now and then, just to check in with myself and make sure I don't have a bona fide, dependency. So I will be drinking coffee again. Actually, I drank coffee this morning because here in Maine, Emily's parents always brew a big pot, so I had some coffee. So I'm not even that good at taking the break, but every once in a while I like to take a pause. Emily, his my fiance, she's been she decided she'd start drinking tea, and it's easier to do things,
Yeah.
together. I don't want
Well,
to
yeah.
drink
If you're in
coffee in front
Maine,
of her when she's drinking tea.
tea is good. That's a New England
Yeah,
thing.
very
I
New
was gonna
England.
say if you're in Maine, you got to get yourself a whoopie pie. Have you had a whoopie pie yet?
I have heard tell of a whoopie pie. I have not had a whoopie pie yet,
Oh
so
man,
definitely got to check that
you
out.
got to get yourself a whoopie pie.
Yeah.
Trust me.
Um, I'll make a point of that this trip.
Yeah, it'll
So
full
I
disclosure.
met Emily in 2019, and the first time I came to Maine was Christmas 2019, and then of course, as you know, COVID was the major event in both of our lives, and so
Yes.
we have been coming to Maine every year for Christmas, but not really like socializing very much. Not that there's a lot of socializing one does in the country, but still, to the extent we could have gone out and got things to eat or seen things, COVID really just changed that
Got
whole
it. Got
pattern
it.
of living. But I think it's coming back.
It is coming back. Well, let's
Yeah.
pivot a little
Yeah.
bit. So let's talk about your law
Sure.
practice. I know you're a litigator, a litigation partner. Tell us about what you
Yeah.
do every day.
Oh, wow. Well, it's a really great question. So on paper, I am a litigation partner. As you probably know, that doesn't really describe the daily practice of what you do. As a partner, you're managing people internally. Obviously, you're managing client expectations externally. So a lot of administrative stuff that happens, everything from department level meetings to invoice reviews. So that's all the stuff you don't really see in any legal drama. I always joke that if there was a true to life legal drama, it would be the most boring
Yeah.
TV ever. Just be a person typing and thinking and having meetings mostly. Um, but yeah, what I like about what I do is the litigation side. I mean, that's fun, and every case has its own twists and turns and back alleys, and so many of them settle, but occasionally they go the distance, and when they do, you learn that case inside and out. It's like a favorite city or something, and you could tell anybody everything, right? Exhibit 200 of this, thing, and this page, like this is an interesting fact, and I think that's thrilling a little bit to keep the edge sharp. And the other thing about what I do is I help people, right? So one of the privileges of being a lawyer is that at the end of the day, we change something for our clients. We change their rights, we change their social reality, we do something for them. If you're transactional, right, maybe you form their company or you put a deal together. But on the litigation side, a lot of what I do is I would think of it as risk management.
Yeah.
Clients come to me in a state of panic, and we guide them through a very complicated process. And if everything goes well, it never even ends up in litigation, right? Sometimes people hire me to stop things. That's the best time to get a litigator, actually, is before there's any litigation, to look at the contract and say there's a big red flag here, or there's lit risk here, or why don't you try this type of demand letter, or maybe we can mediate this, that sort of thing. Because um not to over answer the question, but there's this quote by Churchill. He says, democracy is the worst form of government except all the others that have been tried.
I've heard that.
And I feel that way about litigation. It's the worst way to solve a problem, except when you've tried everything else. It's the
Mm.
least efficient. It's the most emotionally draining. It's certainly not cost effective, but sometimes it's the only option, right? And that's when you need expertise to guide you through what is
Right.
really a very complex process.
So are you
Um,
on the plaintiff side, the defense side, both?
Both, yeah. What I do is complex commercial lit. So usually there's at the core of it some sort of contract. It could be a securities
Okay.
deal, it could be an intellectual property deal, it could be a lending transaction or a license. Over the arc of my career, is still pretty young. I've been practicing since 2008, so I guess going on to 14 years, but I still feel like pretty young in the profession. But over that arc, the subject matter has changed, and but the core of it is always, how do we how, how do we don't have a time machine. We can't go back and see what the people said or did or intended at the time. We just usually have some documents, some contracts, maybe some vague text messages or
Yeah,
emails.
yeah,
These days a
yeah.
lot of things are like that. And how do you fill in the gaps? How do you make a coherent story? Ultimately, how do you take these people from fighting to some form of peace or acceptable resolution? How do you get there? So that's a lot of what I do, and that's kind of subject matter agnostic. But in terms of focus, definitely I've done intellectual property, data privacy, and these days the slight securities experience I have is translated into some cryptocurrency work, because there's a lot of disputes happening, as I
Sure.
think everybody could guess, in the cryptocurrency
Oh
space.
yeah.
So
Well, give me an example of one. You said that, goes all the way through the end I assume you mean
Yeah,
trial.
well,
Give me an example.
this year we had a case that was arbitration, but it was still a 2-day trial with witnesses. I did a 1-hour closing argument. Um, you know, I've
A jury
certainly had
trial? It was a jury trial?
no, it was an arbitrator. It was an arbitration
Arbitrator.
trial. The jury stuff that before I came to New York and before I became a commercial litigator, I did a bit of criminal law down in Texas. That's where you get in front of a jury quickly, is in the criminal side.
Sure.
The civil side, especially for the commercial, where we're not really dealing with tort or injury, so few things go to a jury. So the closest I've gotten to anything like a jury trial has been evidentiary hearings, damages trials, but they've all been before on the bench trials basically.
Got it.
And I do feel like that's a hole in my experience. It's kind of hard to fill in our line of work because jury trials are very high cost and very high risk.
So your arbiter is the judge, right?
Basically, yeah, he's the judge, and well, in this case, it was a he. It doesn't have to be, but he was the judge.
Yeah.
It was tremendous. I have certainly, I had my own practice for 6 years in between coming to Romano and previously being a different firm. So, having my own practice, I did get evidentiary hearings, bench trials, that sort of thing more regularly. But when I was an associate in my first firm, I didn't. It was a partner who was handling that. So now I'm a partner, and I got to be lead in this 2-day trial, which was not a jury trial, but I think it was very very much of an endurance game, and we were working around the clock. Like I said, I gave a 1-hour closing argument. It was one of those cases that had been percolating for years. So like I was saying, I gave that 1-hour closing almost from memory, and I remember that impressed a couple of people, especially the younger associates. But when you've lived with a case for that long,
yeah,
it's not that it's really not that impressive. You pretty much and the lead up to that trial, you eat, breathe, and sleep this case, so that's just what it is. But it was a tremendous experience. The trial went well, which obviously helps. But even
what was the trial about? What was the case?
It was a crypto case. So without getting into too many details, on the surface, it was just a payments dispute, and it not really the sexiest type of thing. But the problem with cryptocurrency is it's so new, and law is always guided by precedent. And with cryptocurrency, we don't even know what it is, right? Is it a security? Is it a currency? Is it a commodity? Is it something else? And oftentimes, is it property? Like when you're talking to the IRS, it's property. If you're talking to FINRA, it's currency. If you're talking to the SEC, it's a security under the Howey test. Maybe not, right? So the thing with cryptocurrencies, you have to build analogies to things that we know, like currency or securities. This case was a payments dispute where we had contracts that had provisions for payment in dollars or in token.
Yeah.
But it was ambiguous who got to decide, what that form of payment was, when the decision had to be made. And the reason this became a big issue in this case is that these contracts were entered into before the launch of the token. So it's sort of like saying before the company, if it's a startup, before the company goes public. It's probably the best analogy. Sorry about that. We got a dog on the Zoom.
Oh, I can't even hear that. I couldn't even hear that.
Oh, great. I changed my noise cancellation settings this morning. Glad that worked. Before the launch, you don't know if this token's going to be worth anything. The company may fail to launch. And then in the cryptocurrency space, if you don't have a mainnet launch, you don't have a viable token, and you can't list it on the exchanges, and you don't have a market to trade the token. So the value is essentially zero, right?
Well, that's one of the problems with those. When you're using tokens as a form of currency, you want to convert that to a stable coin so you don't have those issues.
Right. So the problem here, obviously, is that there were these contracts that didn't really explain. It was really timing problem, right? If there wasn't this huge future contingency that could make this thing worthless or worth a lot, then it wouldn't matter so much when the decision had to be made and when the conversion had to be made. But, the case was about whether a party could wait, for example, until after they knew the mainnet launch was going to be successful to decide whether they would pay in token or dollars. And it's a very interesting problem because, like I said, lack of precedent. So we were, both sides, we were citing Civil War era cases about back when you had contracts for dollar and gold payment. And then the government, essentially government, by legislative action, you could no longer really make payments in gold. So suddenly the value of gold versus the dollar changed, right? Sorry, that's not what happened. You were forced to accept dollar payment, as in any transaction. I forget what the statute was, but this is going back to the 1860s. I think it's like Civil War era stuff.
Wow. Yeah.
It became such that the dollar was always legal tender for any transactions, which sort of changed the balance between gold and dollars quite dramatically. And then you had these contracts that were written, could be a mortgage, it could be anything, that were written such that payments could be made in either. And so, these cases were cited, Russian Ruble collapse cases. We cited cases about, if I have a judgment in English pounds and the US court has to render a judgment in dollars, what's the conversion date? Is it day of judgment? Is it the day that the breach happened? Is it something in between? Who's left holding the bag on that if the thing has gone up or down? These were all questions we were.
Yeah, it's complicated.
Very complicated. Yeah, it's very complicated. And it's funny because when these clients approached us, they had a call with me and they said, "We have these contracts. What do you think?" It's usually how it starts. And then by the time we got to the trial, our thoughts were so much more refined and nuanced and complex. But at the outset, we knew there were issues, but I didn't really know.
So in that case, you were on the plaintiff side.
We were on the plaintiff side. We were on the claimant side.
And you got damages from that?
Yes, we did. Yeah.
Okay.
Yeah. But there was a lot of playing the joints about if party A owes party B X number of tokens, but I have to render a judgment in dollars. And in this case, that token value has gone up by huge multiples and crashed and back up again during the course of the litigation. What is the date? That became a hugely contested issue. Is when do you convert these token to dollars?
Right.
And I think this might actually turn into a practitioner piece at some point. We're bouncing it around internally. Like, it's not a settled issue. Certainly the arbitrator, he was very, very good, but he did not see this as a clear or settled issue. And if I recall correctly, we cited a magistrate judge report and recommendation from the Eastern District that had been issued like 2 weeks before the brief that we submitted. And that was the only real precedent we could find that was even guiding on this point. So very, very tricky.
So you're creating some law. You're creating some law there.
Yeah, we're when you're an advocate, obviously you argue for your client. When you're writing an article or practitioner piece or something else, you can take a step back and say, what do I think the answer should be? I don't actually know what the answer should be. I think with all these rules, what sometimes gets lost in the noise is there's a winner and a loser for any rule that you create. So you're never going to make everybody happy. It's unfortunately what it is. And that's what legislatures do. They make these policy determinations. Who are we going to make the loser on this, and who's going to be the winner?
Right.
It's hard for me as a lawyer. That's not really what I do. I represent clients, so it's kind of hard sometimes to think at that higher generality. Yeah.
So tell us how you got here. Like, how did you get to where you are today? What was that journey like? You said you had your own firm, and
the short version is I didn't know what to do, and I went to law school. I'll tell you the long version. My dad is, growing up, I was really interested in math, and it's very unusual for a quantitatively inclined person to end up as a lawyer. But long story short, I was in college. I was a math major. I had my sights set on academia, and then I think I sort of soured on that whole project of getting a PhD in math. I still love math, and I did at the time, but it just didn't feel like I would be happy in that path. But I didn't really have that realization until senior year of college, right? So I just didn't know what to do. And it was my father who recommended, why don't you take the LSAT? No pressure. He was confident. He said, I think you're going to do well. I took the LSAT and I did do well. And then I had, growing up in Texas, UT Austin is a great law school, and I got some scholarships from them, and I sort of crunched the numbers and realized the worst thing that would happen was a year of my life that I would lose with a small amount of debt, but really between scholarships and in-state tuition. And I worked a little bit, not not an unreasonable amount. So I did
Yeah.
it for a year, and then 1 year led to 2, which led to 3. During that time, I befriended an attorney. His name is Yoav Greiver. He is a University of Texas alum, and he's a partner at a firm in New York, and sort of, he helped me get a foot in the door for an interview at this firm in New York, and then that led to a job offer. And it's sort of been like that. One thing has led
Yeah.
to another.
Wait, your dad was not a lawyer. Is that what you,
No, I know so many people who come from families of lawyers. And
yeah.
my story is so different. It was, I always enjoyed argument. I loved rhetoric. Um, I, I'm not, even though I majored in math, I've loved writing. I'm not afraid of words, so I think it makes sense in a way, but certainly wouldn't have predicted it.
Yeah.
And this journey has taken me all in all sorts of directions I would never have predicted. So,
Nice.
yeah.
And you like the area of law that you're in now. Is that where you see
I
yourself staying?
do. Yeah, I do. Romano, at sort of deep in its DNA, was a media entertainment firm. I think I don't remember when Dominic first founded it as a small practice, probably 2003, 2004. So it's been around a while. But the litigation side is newer. That was 2018. I think they got their first lit partner who recruited me in. But it's been great. My lit side experience has been more shifting into IP, as it were. As a solo, I did a couple of trademark cases, and I found myself doing a lot of startup work, so branding, trademark, thinking about copyright issues as well. I was also doing data privacy work, and that was a really good adjunct for what Romano was doing in the growing lit practice there. So yeah, I think it's been a happy marriage so far.
Well, entertainment and IP, that makes sense. Those go together.
Absolutely.
Yeah.
Very much go together. Yeah.
Interesting. Well, with the math background, maybe you could become a patent attorney. You ever think about that?
It's a great question. I actually did interview at a patent firm, and I got an offer, and I nearly went that direction. But the weird thing is, the patent office, you have to have certain undergraduate backgrounds to be eligible for the patent bar, and mathematics doesn't cut it. So what I would have had to do, I think, is take a separate exam, just to be eligible to then take the patent bar. And like most people, I'm a little bit lazy, so I don't know. I mean, at some point, the effort just seems like it's
Right.
a little bit too much of a long and winding road. So I kind of pivoted, but I kind of, looking back on it, I'm very glad I did that. No knock on patent lawyers. I have a lot of friends who are patent attorneys, prosecution side and litigation, and they love it. But it's specialized, and
Yes,
as a
narrow.
first year, yeah, I think I could, if I really wanted to, develop that practice area, because I have a litigator skill set, which a lot will translate over. But if I had just been doing patents, I don't know that I could, say, pivot to commercial litigation.
Yeah,
I think it's a little bit harder to switch. If you really know that's what you want to do, I think that's great. But it's sort of like if you I remember this friend of mine there, when their kid was in high school, he was a really good runner. He also really loved soccer, and their track coach was trying to recruit him to play, to stop playing soccer and come join the track team. And they kind of kept him in soccer for a similar reason. Track is more specialized, and you run a lot in soccer. And if he ever wanted to become a runner, he would have that experience. But the translating of soccer to track makes sense. The other way is harder. Soccer's a more like diverse skill set.
Got it.
So
Good.
yeah,
That's a
I
good
think
analogy.
that's the best analogy I can think of.
No,
right
it's a
now.
good one. I get that.
Yeah.
I mean, so
Yeah.
you made a comment about you have the litigation skills. What are the skills you need to be a good litigator?
Well, it's a very paradoxical combination. You need to be comfortable wading through a lot of rules on the one hand and getting deep into rules. In the federal courts and even in state courts, every judge often has their individual practices. And then there's the local rules of the district. And then there's now I'm talking about federal, there's the federal rules of civil procedure. For bankruptcy court, there's a separate set of rules. So there's all of that to wade through and kind of synthesize. But then there's this creativity that's required. And the creativity is, I said every case is different. I really meant it. We group cases into causes of action or types because it's convenient. It helps us make some sense out of this massive activity. But a legal case is coming from human beings engaged in some activity, and human beings are very complicated, and
Right.
every case surprises me. Every case has something that requires a pivot or a different way of thinking. It could be small, it could be big, it really depends, but you have to keep alive that ability to sort of always have three independent tracks going at once. Like, it could be this, it could be this, it could be this, and we're never going to know until maybe the very end. So you just have to have that ability. I think that's really important, is some kind of ability that is okay with the sort of deadening bureaucratic rule aspect of it, as well as the creativity. I mean, the other thing I'll say is that most of the problems that seem to appear in a case, most of them go away on their own. So I think the difference between good litigators and really great litigators, and I've had the privilege of working with some, and I've seen it, I've seen how they do it. There seem like there are 10 issues to solve, but they just know 9 of them are going to go away, and they really only attack the one. And takes a lot of I'm not there yet, and that takes a lot of experience, because if you're wrong, you really, you know,
Placing a
it's
bet.
really
Yeah.
bad. Yeah.
That's
But when you
interesting.
have decades of experience, I think you not only can do that, you should, because you help the client, right? For one thing, you reduce their bill, you're much more efficient, and you save yourself a lot of stress as well. So
Is there a way
that's
to
like
play that out and test it so it helps
that's
you?
like the Yoda level that I think I'm aspiring to, and not quite there yet.
Yeah.
Here, just one second. I'm gonna readjust camera to
Is
test it out.
yeah.
Litigation is like a war, and a war has many battles. So I think there are ways to test it out by trying this strategy on a smaller battle in a case, like a lower stakes issue. Maybe it's a very minor discovery dispute, or um, an initial pleading problem, and there could be 7 things that you have to consider, and maybe you have a gut hunch that 2 of them really you don't. If the stakes are low enough, you could try it out. I mean, this is the problem with sort of this is the problem for solos. I think law is an apprentice profession, so the best answer is find somebody who knows how to do this and talk to them. But that's easier in a firm where you have, hopefully you have experienced partners and people who are graybeards, or have been doing it for decades. That's one thing. I think for the solos, for the small practices, this is a real challenge,
Yeah.
to develop that skill set.
Got it. All right, good stuff. What other technology do you guys use in your practice to become more efficient?
Well, this is a
Besides
really
Zoom. Besides
yeah,
Zoom.
no. It's a really interesting question, because technology. So I used to be more in the data privacy aspect of law, but also e-discovery. And what I didn't mention is I had a brief in-house stint at what was then a publicly traded company. I think they were acquired. I forget what happened, but they were really in the e-discovery and cybersecurity space. So very much legal technology space. And, I still have colleagues who basically do that, and I'm in touch with them. I think it's a really interesting question. So on the one hand, technology it's already revolutionized legal practice, right? You have for discovery, you have technology system review, you have artificial intelligence. I think that I wouldn't be surprised if we see in 10 or 20 years completely AI law firm associates. I know with IBM Watson technology, that's something that some large law firms are looking at, because that technology, what it can do is essentially what doctors do when they diagnose, right? It can compare 100 other examples and then say, I think that this case is most similar to this kind of subset, and so this should be the answer. And it's pretty good, and it's only going to get better, right? So that's what's on the horizon. I mean, I think the problem with technology is that sometimes the promise of efficiency doesn't deliver. So a really simple example is, old school lawyers used to dictate. They would dictate into a tape, and then they'd have a secretary type it up. Nobody does this anymore, right?
Correct. My dad used to do that as a doctor in the dictaphone.
Yeah, my mom did it as a doctor, and I was talking to my dad about it, and he made 2 points to me that I just never thought about. One is that when you have this practice of dictating, it sharpens your memory, right? So it's probably does create efficiencies later. For example, you have that case going to trial and you need to remember 100 exhibits. if you have a sharp memory, a practiced memory, it's not as hard of a thing to do. So that's just something I hadn't really thought about. But the other thing is, our clients pay us a lot of money. Generally speaking, this is another privilege of the profession, hundreds of dollars an hour or more to get our counsel. And there's a question of like, should they be paying us to type? Right? It's not that I can't type. I can
Right.
type pretty well, but should they be paying for that? Or should they just be paying for me to think thoughts and then somebody else type? I think that's, my dad's an economist. Of course, that's the way he thinks, right? He thinks in terms of, I guess, Ricardo's theorem of comparative efficiency or something like
Comparatively.
that. But anyway, the point is word processing is such an ubiquitous technology now and so basic to what we do as
Well, you've
lawyers.
probably seen Chat GPT. I mean, a lot of contracts are going to be written through that kind of AI
Right,
technology, right?
right. I mean, so this is something that I think any law firm and certainly our firm and the management are thinking about these issues. How much of what we do can be automated, how much can be sort of like done through smarter use of technology. But I worry about a couple things. I worry about associate training as these functions start to get automated. I think um, just with the economics of the profession being what they are, you know, part of how you learn as an associate is by doing a lot of repetitive, fairly like drudgery, drudgery saturated tasks like document review or, just drafting, like revising the same brief 20 times or something, and that's training is really valuable. A lot of it is written off at a lot of firms. So it's not really billed to the client, but you're investing in an associate when you do that, right? And you're hoping that they grow into becoming an effective lawyer, and then of course they're very valuable to the firm and to the practice and the profession. I do sometimes worry about what's going to be lost if too much of the what I would call first year associate functions or paralegal functions get automated. I don't know that there's a good answer to that. I will say this is one thing that I like about litigation. I think the day when like appearing in court and giving an oral argument is automated is still very, very far away. Like, I don't think a robot's going to take my job anytime
Yeah, I
soon.
wouldn't worry about it.
Um,
Yeah.
but absolutely for transactional work, for contract drafting, and then with smart contracts now, like all of that is going to change so many things. I think the first wave of the word is like everyone uses the word disruption, but the first wave of this was really um, with outsourced legal contract review, which was when I started practice in 2008, that was just becoming a big thing. And other industries had already outsourced a lot of labor, but law is still an ethically governed profession. You can't just do things because they make some economic sense. You also have to follow ethical rules, which means you might need a New York licensed attorney, even if you can get 200 attorneys in India or some other lower cost jurisdiction to do the work. If they're not licensed, so those were, I think, initial hurdles, but that industry matured and it really disrupted um, the legal market. But again, I think the disruption was asymmetrical. It didn't take away jobs from lawyers who were doing more sophisticated work. It certainly took away some of those first year associate functions that I think are valuable. So I don't know. I don't know a good answer to this question.
Well,
I personally,
it's
yeah,
an
yeah,
interesting discussion. I mean,
yeah.
I get
I
what
mean,
you're saying. I think it becomes, AI is being applied everywhere. It doesn't replace it necessarily. It becomes a decision support tool where it's
right,
like
right.
mechanical leverage, right? It's like I don't have to lift up the boulder anymore. I have a lever to help me with that. I still
Sure. I
think,
think
you know,
that's the promise, right? And when I was a solo, I did have to rely on technology for things because I needed that lever, especially with discovery, right? So some of the newer technology around document storage review. I remember a company called Logical that was one of the first. It's spelled Logic, like
yeah,
Logic, Cull, I think Kull. It was one of the first sort of solo friendly offerings that I saw to do law firm style electronic discovery. Driven is another one, driven one. But yeah, I remember that space was really growing and it really was necessary for a solo small practice attorney. how else are you going to collect 10,000, a million documents and produce, you're not going to be able to do it by getting banker's boxes and sitting in a room. You can't do it that way anymore.
Right.
So yeah, no, I definitely think the tech is changing the profession in good and bad ways. And it's an interesting thing to see how this will play out, over the course of what I hope are another few decades of my career. I'm not really sure what's going to happen, but I know it's
I
going to
wouldn't worry
be
about it.
surprising.
I agree with your dad's perspective on allocation of resources. So it just changes what you focus on instead of the mundane things. It's higher order thinking.
Yeah.
Yeah, I agree with that.
Right. That's the best way that technology can be used, is to actually help people to really form and focus in on their core functions. And I think the worst thing that could happen is just taking away this like essential training, and also, like I said, this unseen effect, like how are our memories being affected by the fact that we don't dictate anymore, for example, right? And if you conclude that the loss of dictating has harmed our capacity to remember, I don't think that means we all get tape recorders. I think that means we try to improve our memories, right? We recognize that this is a problem. And maybe there's even a technology solution for that. Maybe there's, there are all these games now that people play that are billed as like, this will improve your cognition or whatever. I mean, I think that technology, I'm not a Luddite, but I just think that there are unforeseen consequences that we need to think about as lawyers. Yeah.
Yeah, we're living through those. So I agree with you.
Yeah.
Well, listen, just to round it off here, because I want to let you get back to enjoying Maine. Just final words you want to leave with the audience about your firm, about you, and the best way to connect with you.
Yeah, so I'll take those in order. So my firm, it's genuinely maybe the nicest group of lawyers I've ever worked with. And I think some clients, the ones who want the aggressive lawyer, may be turned off by that, but I can assure you that we still win cases and we still get deals done. But it's a good group of people, very supportive, really diverse backgrounds and abilities, and so I think it's a great firm. And for me, it's been a great home for my practice. I think, for my own career, this is maybe just sort of general advice about the legal profession, or perspective, I guess. Advice is the wrong word. It took me a long time to realize this. There is a big difference between a job and a career. And a career can encompass, a lot of different jobs, but there's a kind of pattern to a career. And in the legal profession, I think, especially for young attorneys or people who are just starting out, there's a tendency to believe that there's only one track or one thing you can do, but it's actually not true. JD is an open door to a lot of different things. And I see a lot of lawyers burn out because they don't understand that the career is going to last for decades, and it's not a sprint. You don't have to crush the hours every year after year. I mean, it's fine, but then if you leave your firm and you're burnt out, it's not great. There's so much that there's to learn over practicing, one decade after another after another. I certainly, and I may be labeled a hypocrite for saying this because I have been historically a top biller at the firms I've been at. I still am, but I think I'm beginning to understand a lot more when people talk about work-life balance. It's not a cop-out. It's actually a way of staying sharp and staying good and effective for
sustainability. It's a marathon.
Haul. So you got to think about, could I do this in 10 years? Could I do this in 20 years? And if the answer is no, that's okay. It just means that what you're doing now, you might change. But the other thing I find young lawyers kind of get trapped in is like, change means I failed or something. But that's what I'm trying to say. Career and a job are very, very different.
Right.
My sister's a writer, and being a writer as a career is very tough. It's a lot less linear than law can feel. We feel like we have a track, especially if you're in a law firm. She's had to invent kind of her jobs, and she's been very successful, but she's taught, she's freelance, she's worked at publications, she's pitched. She's always been a writer though, but I look at her and I see like a living example of this. What you do as a career and what you do as a job don't have to be, the job can come and go, but the career is what you want to focus on.
Yeah,
and
it's a good way to think about it.
Yeah.
Yeah, I appreciate that.
I don't want to say that, I'm not happy. I just realized how that might sound. It's very good when you find a home. for your practice where you can actually, your job, like what I do today is very different from what I did 3 years ago. And I hope 3 years from now, I'll be doing different cases, and that's fun, but I'm still a lawyer, right? There's still continuity, and that continuity builds experience and judgment and other sort of benefits over time. So that's maybe my big picture takeaway for the profession, that don't be discouraged if you feel like a job isn't right for you. It's the career. They want to be looking at the career. Yeah.
It's fluid. I agree with you. I used to say to people, I have a
Yeah.
crooked path, but it really isn't. What you're saying is that, one thing leads to another, and that's all part of the journey in the career.
Yeah. And it's fine. It's actually better. It's better if that's your path, to just to own that, and take joy in it and learn from it. Like as a solo, I had some great years, and I also had some really tough years, but that all factored into the kind of lawyer that I am. The experience gives you judgment. I think chasing experience is really important, and just being open to experience and understanding that the career is long, right? And that you don't have to do everything.
It's good stuff.
Yeah.
Very wise for a young lawyer. A lot of wisdom.
I'm glad you're calling me a young lawyer. My firm is a younger firm, so I often feel like an old man over there. But
no, you're young. When I look at someone with dark hair, I think you're young. You're a young guy still.
It's the lighting.
There you go. It's all in the lighting. Well, listen, let's call it a wrap here. It was really fun to spend some time with you and learn about your profession and what you focus on.
Yeah, sorry about the camera issues and the dogs and whatever.
No, it's good. It's good stuff. This is all fun. So anyway, thanks for everybody again. Sid Rao with Romano Law in New York by way of Maine, and this is sponsored by EmotionTrac, which is a legal tech platform, and we help litigators prepare for trial and mediation with our software. So thank you again, Sid. Appreciate it.
Yeah.